Call the next case, Volk versus Vecchi. Those of you involved in that case, please come on forward. Good morning. The attorneys who are here intending to make an appearance, will you please do so? And it's Vecchi. I was pronouncing it randomly correctly. Yes. All right. Good guess. All right. Thank you.
Kara Porter and Kristen Kibberts for Carmelita Volk, Kelly.
All right. Good morning to all of you. Thank you for being here. Mr. Pace, we got 15 minutes per side. Would you like to reserve any time for rebuttal? 3 minutes. That will be fine. Any other questions before we begin? Okay. Mr.
I have
Pace?
a quick question. Ms. Porter, do you have enough water? No, I'm serious because it looked like your picture is out.
Well, I think
We're not functioning.
I may have.
Maybe
perhaps
Mr.
I was
Pace
not
can help.
functioning correctly, perhaps, but I
Okay.
was struggling to get it out.
Okay.
I'm just trying
I
to.
think Mr. Pace is prepared to help you out here.
I can share mine if
I've got
someone needs
15
it.
minutes. I can
Yeah.
get it full by then. Wait.
Yeah.
Seriously.
Wait.
Yeah.
No, actually, I'm good now.
Okay. All
I
right.
had a trial once where I ended up knocking the whole thing over. Luckily, it was a flood-related trial, so everybody had
Hey.
a good laugh. But okay.
All right.
Thanks.
Sorry to interrupt.
No problem. Thank you for your attention to that. All right, Mr. Pace.
Thank you, Justices. What we have this case is divided into three distinct issues. I think reading through, I'm very comfortable with the briefing. I think we addressed the legal issues very precisely, and it is in finding a fault in the trial court. The findings of the trial court not properly applying the legal standards necessary, as noting to additional authority which has come out, obviously, as you're aware, 3 weeks ago, the court issued the
Rivet versus Hoppy.
exactly, which two of you are aware of, is drafting that opinion, which addressed the issue of the Utah standard for common law marriage. As distinct to this case, one thing is the court, the parties had a long-standing relationship stemming from California. For the issue we're addressing on appeal is the declaration of a common law marriage here in Utah. The trial court made a specific finding as the law of the case that in determining a common law marriage, they would only look to the facts and circumstances as existed here in Utah and not take any evidence of whatever occurred prior to the party's arrival in Utah. So that was limited by ruling of the court and as law of the case from July, August 2012 to the date of separation, March 2015. Addressing the standard of a common law marriage, the two key issues arising from that is the uniform and general reputation, and is established both by Harris, reiterated recently, that it must be a uniform and general reputation for marriage, and that a divided or partial reputation is not sufficient. And that's been established by White v. Blair, and then continuing on by the overall case of Hansen v. Hansen. That's what we specifically address as the trial court made findings that there was a general reputation of marriage, which we believe is incorrect, but did not make any findings or necessarily address specifically the finding of a uniform reputation of marriage. Evidence was in the record, as we've noted, from
And what do you think uniform means? If there's one dissenter out there in the community that knows the real score, that they're really not married, is that enough? One person out there? I mean, does uniform have to be 100% of everybody who knows these people understands that that they're married?
Well, that's a good question, and that's the point of this is a small case body of law that's being defined, by this case. It depends on the gravity of it. I suspect that, yeah, but obviously there's some point in between there. In this case, we don't get to that because, as I say, I noted, I like what we said in the reply brief, just there's several spheres of people that specifically know that they're not married. And so both in the work sphere, AJ Girela testified both as their long-standing knowledge stemming from California. And John Vecchi did not call every person that knew they were not married and knew the status of their relationship. And that's the point of, out of everyone in the world, there's a lot. And that's the point of, why bringing this case to define what constitutes a divided reputation. Like I say, the trial court bypassed that and didn't address it. As I know, the appellee's brief seemingly did the same thing, simply brought up and saying, or attempted to hold out the incorrect standard of saying, hey, if we're friends and neighbors, they're married. That's what Colorado, and People v. Lucero brought up and was only addressing a general reputation. The Colorado court there specifically was not addressing a uniform reputation, which is what Utah has held out, saying there can't be.
Let's talk about a couple of your witnesses more specifically then.
Sure.
The HR manager at the office seems
Right.
to me somebody I can compartmentalize, right? You would want to tell that person what the real story is because it matters to sort of health
Exactly.
insurance procedures. And it seems like just the fact that your HR manager at work knows that you're not actually married, so there's some insurance implications that follow from that. That seems like it would be a pretty harsh rule if that alone would defeat somebody's ability to prove a uniform reputation. Do you agree with that, or do you take the position that even knowing the HR manager would be enough to torpedo that?
I think that's correct. I wouldn't view it as harsh, but it's simply correct. It's saying to the sphere, in that instance, saying to HR, it'd be easy to say, we're married, we meet that standard, we've declared to ourselves we're married, and so we're married, to take advantage of that rule, specifically in
Well,
saying, I'm
except
not
that it
married.
might-
Does federal health insurance law
Right.
allow for common law marriages to count?
It doesn't require a common law marriage.
But wouldn't it void the insurance
Uh,
if he incorrectly reported their legal status?
Well, Utah allows for that. And so if
Well, if it's
it
been
wouldn't, 'cause you
declared.
could come and get, if it became an issue, I mean, the federal law avoids a lot of those questions. I take it as evidence that he had not consented in Utah to being married, because if he'd wanted to declare, under Utah law, if he declared, yeah, we're married, that would have been evidence to come to court and for him to declare, we've got a common law marriage. And
The
I can
HR
take
manager
advantage
is
of
going to
that.
say in response, well, what's the proof that you're married? Do you have a marriage certificate, or do you have a court ruling saying that you have a common law marriage? And at that point, they didn't have any of those things, right? Don't you need one of those things in order to qualify under federal health insurance law for whatever benefits in here to married couples?
If he'd wanted to, he could have, that's what the law allows for. Utah allows for that, the point of saying under White.
Well, sure, but
in
the HR
description of-
manager's got to sign him up one way or the other that day, right? When he comes on board, what is
Right.
he? Right? Who's on this plan today? Right? And so if he goes in and tells the the HR manager, nah, we're actually not really married. I don't know. I'm just being frank with you. That seems like that alone probably isn't going to be enough to say, as a matter of law, that's not a uniform reputation. I mean, agree, disagree?
I mean, I think you're addressing it properly, and that's, we're defining what Utah law means for that. I tend to think, for me, that's what we've got the law for those circumstances. If he'd wanted to declare, I'm married, he would have been for purposes of the law. The HR manager didn't need
But
to
he
question
did
him.
in the context of a loan application, right? Mortgage application.
Yes,
So,
but, and then,
so if there's one person in the world who knows that they're not legally married, then they can't have a common law marriage.
I'd say that's a good question. I guess I'd say potentially, as a thing, that's not the situation we're confronted with. I mean, that's the question of what a uniform,
But he
a
doesn't have
divided
much more than that.
reputation
I mean, here you've got, it seems to me like you're arguing that uniform means that if there is an exception, then it's not uniform. Is
Correct.
that your argument?
Yes, I mean.
So if
that's
one
the Utah
exception
case.
is enough to make it not uniform?
Well, the Utah law is a divided reputation is not sufficient. And I guess I say, one, I want to.
Right, so does one exception make it divided?
Can you,
Accepting Utah case law, I'd say yes.
can you spin me?
If the courts want to say, well, that's not quite enough, that's for you to define, but
Well-
as it stands, I'd say yes.
Can you spin me a hypothetical where that would be true, where 100% of people, where there would be no exceptions? I mean, the party's parents don't even know. Can you really say that there's a hypothetical out there where literally no one on earth understands that these people aren't married? Everybody else, other than the two of them, thinks that they are.
Sure, because that's what Utah common law marriage is set up to define. I mean, it's saying for common law marriage, we didn't go and get a paper, we declared to ourselves we're married. And that's the consent prong of Utah. And that's the consent prong of saying there has to be consent seriously given at that moment to declare we're a marriage, which we also don't have, and there was no discussion of it whatsoever, and there's no facts with respect to marriage. Common law marriage was, we didn't bother going to court, but we said we're married. So you tell everyone we're married. But we never went to court, but we declared our married, and that's what common law marriage historically was. We declared to ourselves we're married because we don't want to go to the courthouse, we don't want to waste that expense, but we believe we are. Utah's codified that. And I'd say historically in the stance of polygamy, to declare there are people that are declaring themselves married, and the state wants to be able to declare that they are married, but it's based on them declaring we're married. We're married in the eyes of God, we're married in the eyes of ourselves, but we haven't gone and gotten a paper from the state. But it requires a present consent. So they're the two prongs John didn't meet. It requires a present consent, and that's the status of during the entire time they were in marriage in Utah, they were together, but their relationship was on the rocks and eventually led to, them separating, led to, splitting apart. They didn't have children here, they didn't have any of those. So skipping forward to the issue of consent, that never, the separate prong, that never got addressed here in Utah, and the findings don't address at all with respect to the time in Utah making any specificity as to that, and it simply didn't arise. And that's giving the context back, if you read through the findings of saying, yeah, this long-standing relationship, but there were several things that sent even their emotional relationship awry before coming to Utah.
But can't consent be inferred from things like, thank you to my wife for throwing my surprise birthday party?
Consent can be inferred, but again, in noting it's the exception, in noting White, noting the statutory standard of given for consent as quoting. Simply that the hallmark is a written paper saying we declare we're married, and an exception to that can be shown by acquiescence and a general reputation,
So
but that's the exception.
Aren't you declaring you're married when you fill out a loan application and say you're married?
No, you could be, or that's evidence of it, but it's not in the sense of you still create a unified, that did not occur in every instance.
Let me ask you about the standard again, uniform and general. You've defined uniform in your brief. What's your definition of general? A general reputation. Because I've looked it up, and one definition is considering main features and disregarding exceptions.
Right.
So if uniform means there can't be exceptions, but general means there are exceptions, how do we interpret the phrase uniform and general reputation?
Well, I like what the courts do. I mean, I'd give the same quote. General, I'd quote what Lucero says and Utah says as far as general, but Utah makes a point of adding something onto it. So giving words their effect, we say there is something additional to it.
Right, so
General,
how do they work together is what I'm trying to figure out.
General means you've got different spheres of life. The example they give in Lucero, they quoted Hansen, is one aspect of that is your friends, neighbors, people that you're around, people that you're seeing. But that's just one aspect of it. If there's a completely separate sphere where everybody knows, so it's like we just moved into a new neighborhood, we don't bother telling anybody we're not married. What we do inside our house remain content, and everyone gains the impression.
But it wasn't even like in his other sphere that everyone at work understood he wasn't married.
Right.
I mean, HR understood it.
Right.
And she apparently told the CEO, but that's why he
Exactly.
understood it. It wasn't as though he was out there representing that they weren't married. He did it in a very limited
Well, I wouldn't say-
disclosure, right?
Well, not limit.
At least there was no evidence that other people he worked with perceived
Well, the point,
something
and I
different.
guess that's the point. If you don't need to bring in you don't need to bring in every person in the world that knows you don't. I mean, it's just the demonstration that I've got, that's how the answer to your question. If I can demonstrate that there are spheres, I don't know the full extent of it. I could see, as a declaration, if we can show there's one person that, if my parents don't know that I'm married, I think that could be a big enough sphere to say that's a divided reputation, because that is one big aspect of life that has not been made uniform and that's not general, because it's a big enough thing. One person down the block knows and doesn't tell anybody else, maybe that's a small enough exception to not worry about it. But if there are big enough spheres that know they're not married, then that is divided. If everyone at work knows
But
they're
did
not.
everyone at work know? I don't think there was evidence.
Well, he didn't bring in, but he showed enough people.
Well, but he
HR,
showed an HR person, which he disclosed it to her because she was dealing with his benefits, right? A very specific reason, not even just some random person he has lunch with in the lunchroom.
Sure.
This is like a very kind of unique disclosure, isn't it? So does that suggest that we should infer from that that everyone at work understood it?
But you could have, there's the balancing of what you're going to do at trial. I forget the exact phrase for it, but, balancing what you need to do and whether we need to call in.
Sure,
other
I
people.
understand.
She was there. She knew. She testified. I opened my mouth and told other people. We brought one example of Steve Schillingford, of someone that had heard words for it. There's an inference that more people knew, but at least at work, people didn't know. Also, you have AJ. So you have at least, there's a group. AJ is representative of people in California, and he was also present in Utah. So you have work, both in Utah and California, knowing not. You have work professionally, knowing. That's the point. There are examples, yes. Yes. At certain points, he signed, declared, I'm married, and whether for mortgage purposes, other things, are taking advantage of it. But in other circumstances, he said no. In filing taxes, could have declared married, but it said declared himself head of household, and made the declaration no. And so,
And what
to
is it?
stretch the parameter, you could make a
What
full
is it
declaration
that-
if there's nothing, but I think there's enough there with the definition of the clear spheres is established. It's clearly a divided reputation.
What is it that these people have to know in order to sort of help you establish that there's not a uniform reputation? Right? Do they have to, is it just that they have to know that they're not actually solemnized? Or is it they have to know that they don't even intend to sort of be a common law couple? Do you understand the distinction I'm trying to draw
I
there?
do. I mean, I suppose both. I mean, we just draw lines on the facts that we've got, and you not try to make hypotheticals. In this, so I could see situations for both, or declaring that, yeah, we're specifically not being married. We want to just be a couple, and we want to be free to separate at any moment and not have that back. I mean, to that extent,
Well, for
that's knowing the
instance,
clear line of I'm not consenting to a common law marriage. I don't want that.
there's this witness that they called, I forget her name, somebody will tell me.
Shannon
Shannon?
Evans?
Shannon Evans.
Shannon Evans.
Sure.
Who, she knows they're not married, but she has the understanding that they are basically,
Husband and wife.
they're husband and wife, even
Sure.
though they're not. Her understanding is essentially that they are a common law couple. Right? She knows the entire story and sort of agrees with these guys, right? So is that person on your side of the ledger or on theirs?
That's an interesting. I know
That's
we
what
cite
I'm
that.
trying to get at with the question, right? Does the person actually have to know more than just that they're not married in order to help you?
A little of both, and again, you've got the two prongs for it. I think Shannon Evans helps, and the court didn't make demonstrate the court didn't make findings, including her testimony concerning that, but I think it was necessary. She demonstrates there wasn't consent. It's like, I know they're married, okay. I know they're not married, sure, they look like a couple, but to me, or to my understanding, Shannon Evans' testimony, which is in the record but not included, where she knows, yes, I did know, they'd been told that I weren't married, they looked like a couple, but that's the point of saying, since we didn't consent with the president during the time we were in Utah, since we didn't consent to be husband and wife, to be a married couple, but just to be two people living together with the residuals of a contract, which we dispute from from California, we're not married under Utah law, and I believe that's the standard. You can't. There's no description of they consented. It's actually the opposite. They didn't consent while they were in Utah to be married under common law. Distinction. I mean, under this facts, I think it's clear. I can address the hypotheticals to get a better understanding of what the limits of the law are, but I think this had served to delineate where you've got clear, separate spheres of people that know they're not married. That creates a divided reputation. It also establishes there wasn't consent, and you've got an abuse of discretion by the judge by refusing to rule on the division
All
of
right.
the custody evaluation.
Thank you, Mr. Pace.
Thank
Look
you.
forward to hearing from you again on rebuttal. Ms. Porter?
Thank you. May it please the court, counsel, Kara Porter, Carmelita Volk. I'm going to approach this slightly differently, but obviously I'm going to try to address everything I've been hearing the last 15 minutes. But there is, in fact, a fact finding that has to be challenged through the normal methods that is at issue here. The fact finding is on record site 2806, paragraph 114. And of course, there are a lot of them collectively too, but this one very specifically is a fact finding of a uniform and general reputation. So once you have that fact finding, then the burden now becomes to show that that fact finding is clearly erroneous. And what has been cited are three individuals. I was going to say the same things about HR. I mean, the last thing you want to do is go in and not explain the status to somebody who has to make sure your health insurance is good. So the HR is something that you basically have to go in and say, I don't have a piece of paper. Then you have the other two individuals that are cited. One is I'm just calling it a friend, but it's Shannon Evans. And you remember, they have to show that the court could not have interpreted this evidence in reaching the fact finding that it did. And I want to go there on what it was that Ms. Evans had to testify to, or that Mr. Uragala had to testify to, because I think it's fairly clear under the statute that they have to know that it's unsolemnized and not a marriage. I mean, we were all loosely using the phrase married. They knew they weren't married. What they said was they knew as AJ put it, he knew they hadn't been to court or whatever to make it official. And so, and yet, even AJ, which was their best shot, I mean, that was, they brought in one friend of his and an HR person, and that was what they had. So even their best shot answered all the questions in terms of what the nature of the relationship was and described a marriage. He just said, I knew it was unsolemnized. Because he said, I knew this wasn't boyfriend-girlfriend. I knew, they had children together and all of these things. Their children had their names, their joint names, which itself is holding out their relationship as being akin to a solemnized marriage. But so they don't get it from AJ, because his only thing is, well, when you say not married, I think, well, they haven't been to court or whatever. And of course, Shannon said, well, she did tell me that they didn't have the paper or their certificate, but they were married in every other way. I mean, they were married. And then, of course, there was the whole slew of witnesses that came in and said, these guys were married. That's my understanding, all of that. I believe the burden here, I hope we don't have to get to the point where we're trying to come up with some new or novel interpretation of the word uniform, or, because I don't want to deal with, I don't think we need to deal with that. I think you've got the facts, the factual basis to say, even under, their definition, or just under the common definition of uniform, there's plenty of evidence to support the trial court's finding. I do want to just toss out, even though I would really rather you guys not base this on, any sort of novel interpretation of a statute or anything. Given that the word general does mean that it means you're going to have exceptions. I mean, that's built into the definition of general. Uniform, and this is consistent with the Webster definition that is in their brief. Uniform talks about being the same, things like that. And I think that's really more just in terms of
Unchanging in form and character is the other definition I pulled from.
Right. And so basically it's just the kind of thing where it's not sporadic. I mean, they don't move in and then move out again every month. They don't go and, except unless, I don't count cheating as this, but, they don't go out and see other people and hang out for a year with other people and then come back. I view it more as, if this thing were sporadic and erratic, and if there were temporal, large gaps that weren't just caused by travel or occasional spats. I mean, it's funny to say that their relationship being on the rocks, somehow makes this less like, or not a marriage. I mean, I don't even think I need to finish my thought on that, but that's certainly not inconsistent with some marriages.
If it never was, maybe it would be inconsistent, right?
I mean, that's the thing. So
Every
yeah, I mean,
relationship.
yeah, very few perfect marriages out there that don't have spats. So I view, just to answer the question, I view it more as the form or the nature or the character remaining essentially the same, and it did throughout this entire marriage. Also, I'd like to note that in the Hansen case, which they rely on heavily, there's the discussion of divided or partial, et cetera. And one of the things that this court did was it also looked, because all of these factors interrelate. And for example, in Hansen, the court talked about the white factors, which also can be consent factors. And if you think about it, one thing that's interesting about the white case is that the court in that case listed examples of probative facts. And the facts that it listed, and I thought I had it up here, but I may have it anyway, the facts that it listed, we literally have 100% of them here. It listed facts like joint ownership of property, joint accounts, either the spouse / wife or the children having the name of the spouse. You know, it listed all of these things, representations, all of them. We literally have 100% of those. And those don't just relate to the issue of consent. They were looked at in Hansen as also being relevant to the issue of the uniformity of the reputation. And we really have all of those things here. We have Mr. Vecchi himself testifying that it was very natural to refer to each other, to other people, as husband and wife, and that they did it, quote, all the time. And he said, well, it was for convenience, or I believe he actually took the position at trial that he was just lying when he filled out the bank forms and said she was the wife. I don't know if that had something to do with why the trial court found his testimony to be almost uniformly not credible, but it doesn't matter. They're still representing it to third parties. He's getting a benefit by representing it to third parties. So it seems to fit everything in this case. It is uniform. It never changed, other than the way regular marriages change. Even the evidence they cited just said they knew it wasn't solemnized, but it wasn't like they didn't consider it an actual marriage. They just knew there wasn't the paper there. So they haven't overcome the burden on that. With respect to consent, I'm just going to mention something about the polygamy. I hope you guys aren't thinking, well, gee, we better be careful we don't do something that somehow, changes the law on polygamy. Among other things, the statute does require that you be otherwise eligible to marry. And so there are already restrictions on that. Whatever is done under the facts of this case is not going to somehow, change the law on things like polygamy.
Well, isn't the legislature considering a change to that as well?
Well, at least they're
Now that you've brought it up?
I think they're thinking of like the Senate did pass the decriminalization.
That's what I'm talking about. So when you're talking about eligibility for marriage, isn't that what they're changing?
Well, I don't know. It means you can't be
they're
prosecuted.
endorsing it. Yeah.
I'm not sure yet, because they're not done. I'm not sure yet whether the final wording is going to make people eligible to marry.
Or just decriminalize it?
Or just decriminalize it,
Oh,
maybe
yeah.
baby
All right, I
steps,
see your
maybe.
point.
I don't know, but I'm just saying that nothing that applies the facts in this case is going to, somehow have some dramatic overarching parade of horrors. Also, I wanted to just mention on the consent that not only do we have literally 100% of the probative factors that were used as illustrations in white, but also remember that consent can be inferred from acquiescence. And here, we not only have acquiescence, we have affirmative statements and acknowledgments by Mr. Vecchi. He himself was referring to Carmelita as his wife. He was standing right there when she would enter, here's my husband, and he didn't say, hold it right there. He would be like, oh, and acknowledge it and proceed. So it's more than consent or acquiescence in this case, but even that would have been enough. for the court to find. And so, with respect to I guess the overarching issue that we just heard, are there big enough spheres? I agree with,
Ms. Porter, can one party make it so by declaring it so?
you mean could one person unilaterally?
Yeah.
Yeah, I mean, that's so far different from what we've got here, but I actually I think to have consent, the other person would have to at least know. Now, suppose he trailed along behind his wife behind Carmelita at 50 parties, and she was just running around telling everybody, this is my husband, and he never said anything about it. Would that itself be enough? I almost, in a bench trial?
I mean, maybe it's weird, but can it establish a legal relationship
Well, if you think about it,
if he never objects?
If he never objects, because think about it, can unexpressed intent, I mean, she's, under our hypothetical, which is way, doesn't involve having children named after him and things like that. But under this, how can his unexpressed intent, that under our hypothetical, how could that not at least arguably support a bench trial finding of acquiescence? I mean, we have so much more than that, but it's an interesting question.
You have 80 pages more than that.
We have, yes, we do. We do, but I mean, I always like these hypotheticals, but, well, sometimes I do. Anyway, and so I just want to conclude that the fact-finding has not been overridden here. We've already addressed the issue about the cost and how the trial court is allowed to do fair and equitable allocations.
The court did reserve it for trial, right? I mean, in his order ordering Mr. Vecchi to pay the initial custody evaluation, he said that whether we split it will be reserved for trial. So was it incumbent on the court to address it specifically?
Well, I guess I don't think so, because I think there are a lot of cases out there where you guys and the other folks down there have said, sometimes trial courts don't expressly mention something, and you can reasonably assume it's been implicitly addressed. And in this case, the court said, I think that the allocation of what I've allocated is a fair and equitable division. And he was allowed to take into account the fact that while Ms. Volk was being denied use of any of her funds to, pay a lawyer and things like that, that Mr. Vecchi was unlawfully just dipping into those frozen accounts at will. So he was, even if there hadn't been a challenge or an objection, the court was allowed to take that into account in weighing the equities. So that's what we would suggest on that one, and I would simply submit that the burden has not been even close to met in terms of showing that the fact-finding of uniform and general reputation or consent
Let me go
was
back to
clearly
costs.
erroneous.
Let me go back to costs for a second. I think the words that the judge used was each party was to pay their, quote, own costs. Is that the provision you're referring to when you talk about
Yeah,
the judge made an equitable decision? So
well,
in this context, I mean, can we be confident that the court was trying to include this evaluation in own costs?
Well, yeah, I think we can. I mean, I know that you could say, well, maybe there was a more technical term that was meant, but this court, one thing about this ruling and its length and everything, the court was pretty good at going through everything. I think it's reasonable to believe that based on its other language in the ruling, that what wasn't addressed was going to be simply borne by the party that bore the expense. I think that's reasonable. I think that the burden is on them to show that that the opposite is true, and I don't think that they've done that. I also don't think that they've shown that it isn't fair and equitable. Whether the court addressed it or not, it certainly was reasonable. So based on that, I would just submit on the briefing and ask the court to affirm. Thank you.
Thank you, Ms. Porter. All right, Mr. Pace, rebuttal?
The three issues are, one, dealing for standard for a question of law or ascertaining whether the law was correctly applied. It's simply for correctness. And evaluating whether that law was applied correct, I'd say the burden of proof at trial was to find it. And so discussing the burden of proof, we could want to place that in the context.
Don't we have case law, though, that says this is a mixed question of law and fact, and we review the court's application of the facts to the standard for an abuse of discretion? Isn't that what our Supreme Court said? I think in Clark, although I might have that wrong.
It, maybe, and I'm sorry, and my hearing's a bit fuzzy on saying, I will say, whatever your evaluation is correct, but I say to the extent that we're just not acknowledging that the initial the initial burden of proof did lay
Was on her.
Carmelita as far as bringing that. And so
Absolutely.
the sense of she needed to bring enough to show that there was that. And so as far as the evaluation or application of the facts, the burden is on them to show that there's not a divided reputation. The burden on them is to show that there was consent. And so laying that as the burden of proof. In noting, and not for pure volume, it's a very long opinion, but as noting through in establishing a uniform reputation, it's incumbent to say, regardless of the 90, there's nothing in there where it makes an application or discuss. Actually, what is in there is acknowledge that there are people that demonstrate there's a divided reputation. And it's not create a new law. It's simply applying Utah law of saying we need a divided reputation does not count for that. That's the burden, that's the hump you have to get over. And that exists in that case. That's already in the findings. Concerning consent, I had it in front of me, but noting, this case will clarify this, but the issue of saying consent may be established by acquiescence, but the hallmark is the consent is saying must be seriously given with the deliberate attention that marriage result presently thereof. The quoting back to White and giving the same idea of saying consent in common law marriage must be executed immediately or not at all. And so, I read as the discretion, it's as I say, or as my interpretation had been of understanding, that finding consent, which is separate and an additional finding aside from the uniform and general reputation, is at some point in time, it's formation of contract. You can try and prove you really consented and you're lying about it now by showing acquiescence, potentially. But if the consent never occurred and you can't, it did actually have to happen. This is just declaring, well, we've been in a relationship for 16 years, unless that evinced a present tense at some moment in time in Utah to consent to being married and declare we're married and not separate from that, you don't have consent under Utah law. They're two separate requirements, and they have to build on each other. Also, the quick note concerning the costs. Yes, the judge specifically, I think it's very clear from the record that it's something the judge missed. It was preserved. They submitted by their findings of fact a specific request for those costs have been reserved by the trial of saying, I am going to rule on this. Failure to exercise discretion is an abuse of discretion, so I believe it's a clear error. And the point of the trial testimony, it is still each aspect being for that. Both of them benefited from, this was resolved prior to the trial. Both of them benefited from the custody evaluation. Both of them got that. She acknowledged at trial, I have no objection to these costs being split.
But in ordering that each party would bear their own responsibility for their own costs and fees, did the court not resolve it? Even though it didn't specifically
I don't
carve it
believe
out?
so for the reason of there's no specific, there needs to be some evidence in the record of the reasoning and the thoughts behind that. And so specifically as the custody, that's something jointly applying to both parties to the sense of the costs. The answer to that is that's not Mr. Vecchi's costs. Those are court costs and what should happen to those. It's
And-
custody evaluation benefiting both parties.
Was it
should
incumbent
both
on you to ask the court for additional findings then? If the argument here is that the findings were inadequate,
That's the legal procedure for this. I'm saying, I came on an appellate counsel looking at that. I believe it's clear, I think it was preserved by the findings of fact, clearly making their request for that, their fact by being in the record as far as not having to do the multiplicative thing. It's a clear error that the court just missed, and that should be addressed. I think it was maintained for appellate purposes for that. And the other point, even just noting, wasn't specifically gone into in the record, but Crystal Kelshaw even is noting, she wasn't just someone that John interacted with at HR once. She was the vice president of the company. She worked with him. She's someone that he had extensive interactions with. So it's still just demonstrating you've got additional series where people go through, and the findings are different for that. Do you have any additional questions? But I thank you for your time.
Thank you, Mr. Pace. Thank you, Ms. Porter. Thank you both for coming down and making the arguments today. We're going to take this matter under advisement, as we usually do, and we'll issue a decision as soon as we're able to do so. Thank you. Court's in recess.